The Act recognizes mediation agreements, which is good, but leaves them toothless, which is not good. Mediation agreements or agreements to mediate are defined and recognized, and if you look at Section 4, some formal requirements are prescribed and explanations given. As such, mediation agreements must be in writing. It may be a clause in an agreement or a separate agreement. It may be incorporated into an agreement by reference. Parties may agree to submit both existing and future disputes to mediation. These requirements are very similar to those of arbitration agreements. If you look at it, an agreement to mediate is effectively an agreement in restraint of legal proceedings, making it void under Section 28 of the Indian Contract Act. The Mediation Act, however, amends the exceptions, both 1 and 2, to Section 28 to make mediation an exception to that rule, just like arbitration. A mediation agreement thus stays valid despite the Section 28 rule. What if a party breaches an agreement to mediate? If two parties enter into an agreement to mediate, and when a dispute arises, one of the parties say, "I don't want to mediate," effectively breaching the mediation agreement, what's the remedy? There is no provision for stay of proceedings for the court to stay the proceedings before it initiated in breach of the mediation agreement. You will see local and overseas examples. In comparable situations, Section 8 of the Singapore Mediation Act 2017 provides for a stay of proceedings. In a more direct way and closer to home, Section 8 of the Arbitration and Conciliation Act empowers the court to refer parties to arbitration. But the Mediation Act is quiet on that. Clause 20 of the original mediation bill required the parties to attend at least 2 mediation sessions before they can withdraw from mediation. A failure to attend those 2 sessions may result in a discretionary cost sanction by the courts. While it was not an ideal stick, it was better than nothing. See the Act. There is no such provision, no compulsory participation or cost sanction. Thus, in effect, the Act provides no specific consequence for non-compliance of a mediation agreement. Remember, it is one thing to say that the parties should not be compelled to mediate where they have not committed to mediation, but it's quite another to say that the parties should not be held accountable for what they have agreed here to mediate. You must also understand this in the light of the common law position on enforcement of mediation agreements. While the Commonwealth courts have lately enforced mediation agreements, there are some dissenting views still. So, we missed out a chance to finally settle that common law debate on the enforceability of mediation agreements in India. All said, however, we could possibly argue that Section 7 can be used by courts to refer the parties to mediation where a party comes to court breaching an agreement to mediate. It may well work, but from the wording of the section, it looks like a blanket empowerment for the courts to refer parties to mediation at its discretion rather than a provision to address a breach of an agreement to mediate. We could also argue that the courts could use their inherent jurisdiction to stay the proceedings. Again, possible, but when you enact a legislation as comprehensive as this, it's always better to have a clear provision for the enforcement of an agreement to mediate.